Yeah, that's, I just want to. All right, good morning, everybody. It's Thursday, December 16th, 2021, and this is the regular meeting of the California Fair Political Practices Commission. Ms. Linker, would you please call the roll?
Commissioner Baker?
Here.
Commissioner Cardenas?
Here.
Commissioner Wilson?
Here.
Commissioner Wood?
Here.
Chair Matich?
Present. Well, good morning, everybody, and happy holiday season. I wanted to begin with one brief staff announcement, and that is that we recently learned that our Chief Information Officer, Larry Crabtree, has decided to retire at the end of this month. So congratulations to CIO Crabtree. Just a brief word about Larry. He has been a fantastic addition to our agency. For any of us who've worked with him on IT projects, he's timely, he's responsive. He's been with us for 6 years this month, after spending about a decade in state service. And during his time here at the FPPC, among his many other accomplishments, Larry helped us develop a new search function for our website. He helped us develop our audit time tracking system, our conflict of interest tracking system, and also the Form 803 behested payment report online system. So on behalf of the Commission, I'd like to express my gratitude to Larry Crabtree for his time and service with the agency. And happy retirement, Larry, if you're listening. All right, with that, we'll go ahead and move to public comment for items not on today's agenda. Do we have any public comment?
This is Hank Creasock. Okay.
You go ahead.
Oh, okay. This is Hank Creasock. I'm a resident of San Simeon, and had a couple of items I'd like to cover. First, though, I'd like to thank all of the commissioners and staff for all of their work they've done for our small community. Yes. Can you hear me?
Yes, we can. Please proceed.
Okay. First, I'd like to thank the commissioners and the staff for all the work they've done for our small community. That was really needed and greatly appreciated by many of us in the community. There are two items. One, on December 8th, I sent an email, an attached letter to the commission assistant, and I asked that it be distributed to the commissioners. I hope you got that. It was a letter from Charles Grace's attorney, Amber Maltby, to San Simeon demanding indemnification for all of Grace's legal fees related to the FPPC and the SLO district attorney actions against Grace, which are still just beginning to unfold. And I just wanted to make sure you did receive that because I didn't get any acknowledgement of that. If you could just let me know if you received that, if it got distributed to you. It was my email along with a one-page letter from his attorney.
Thank you. We will look into that.
I don't know.
Comment?
Okay, so you're not sure if you got it? Or I'm sorry.
Did you have a second comment?
Yes. The second comment is that in October, when the commissioners had an extended discussion of Grace's actions, you asked about other Grace violations. In addition to the San Luis Obispo County DA's office investigations, there were a number of citizen complaints filed with extensive supporting detail and documented evidence. I've been advised that these complaints have been dismissed, and I doubt if, like us, the DA's office is any happier about the dismissal of all the other complaints. It is believed that these complaints should be given additional consideration. I know it's not illegal, but Grace's attorney, Amber Maltby, worked there at the FPPC and appears to have, still, which is not unusual, long-term friendly relations with staff, which is fine. But I do believe that these complaints were material and substantive and should be given additional consideration. So I'd just like you to think about that as commissioners. Those are my comments. Thank you.
Thank you. We'll make sure to check in on your comment letter. I certainly don't remember seeing that, but we'll check with staff. Thank you. Next public comment.
Thank you.
This is Steve Petzold in Santa Clarita, California.
Happy holidays, Mr. Petzold.
Well, the same to all of you too. I just wanted to follow up on my public comment from last month that I really do think it's only appropriate that if a complaint is originated with a citizen and there is a finding that results in a penalty against the respondent, that the complainant should be able to participate in that, perhaps like 10% of whatever penalty is assessed. As a complainant, it costs me money to have to travel to LA County to get the records, to spend time analyzing them. And I think we are an important part of the enforcement of the Fair Political Practices Act by filing the complaint. So I don't know whether that can be done administratively or whether it needs to be legislatively done through legislation, but I think it would only be fair if complainants were able to participate in a small portion of any valid complaints that are put forward. And I will end my comment with that. Thank you.
Thank you, Mr. Petzold. Just for the benefit of the public, first, I want to thank all folks out there, members of the public, who have assisted us with bringing complaints and potential violations to our attention. That is an integral part of ensuring robust enforcement of the Act. The Act does not provide currently for us to peel off a percentage, if you will, of a fine for a citizen that does that. That would require legislation. So, Mr. Petzold, I'd suggest to you that if that's something that you're interested in, that you contact either your state assembly person or senator or both, and propose that as a legislative idea. So, thank you again, though, sir.
Thank you.
Do we have any?
And I also have comment on the Stanislaus, so I'll stay online.
Excellent. Thank you. Do we have additional public comment under item 1 for items not on today's agenda? Hearing and seeing none, we will proceed to item 2, approval of the November 2021 Commission hearing minutes. Do any commissioners have edits to the proposed minutes? Hearing and seeing none, do we have any public comment on the minutes? Hearing and seeing none, Ms. Linker, would you call the roll, please? Well, I'm sorry, do we have a motion to approve?
So moved.
Second.
Motion, second, Ms. Linker.
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. We'll now proceed to item 3. This is one of our items from our legal division, and this is adoption of proposed Form 409 for limited liability companies, or LLCs as we've referred to them in the past. And this is a form that we have developed in response to the legislative proposal that we were successful in having adopted last year. So we'll welcome to the table Senior Commission Counsel Erica Boyd.
Thank you, Chair. Good morning. Good morning, Commissioners. I am here from the Legal Division to present Form 409 for your consideration and approval. As the Chair mentioned, this is being developed in regard to SB 686, which was a Commission-sponsored bill passed last year, signed by the Governor in September and goes into effect January 1. It's going to be Section 84109 of the Government Code. Essentially what this is requiring specified limited liability companies, I'll call them LLCs from here on out, to provide a statement of members once they reach certain thresholds for their participation in elections in the state of California. So the contents of the statement, once the LLC qualifies as either a committee or a sponsor of a committee, they will need to file this report with the Secretary of State. Perhaps most importantly, at the top, they will include the name of a responsible officer or a principal officer. This will be an individual. I think that in prior presentations, we went over the challenges that are sometimes faced by contacting an individual associated with an LLC as they're participating in California elections. So hopefully having that person's name and contact information will assist with that. Moving down the form in Section 2, the LLC will then include the names of members who are either have a membership interest of 10% or greater, or have made capital contributions of $10,000 or more in the last 12 months prior to the date of qualification. So those are the two types of members. So if someone has less than 10% membership or has not reached that capital contribution threshold, they will not be listed on this form. Additionally, should any members listed in Section 2B in LLC itself, there will be another layer of disclosure required where members of that LLC will need to be disclosed as well. So essentially, there'll be a full 2 layers of disclosure about any funds coming from LLCs into California elections once they reach these specified thresholds. The form is available on our website. You can download it as a PDF, fill it out, get it signed, and then for the time being, it will be submitted as an attachment to an email sent to the Secretary of State. Once CARS is up and running, this should be a completely electronic process, but until then, we will be going about it this way. What else? We had a 30-day notice period for this at the beginning of November. We did receive one public comment that the form was originally 419, and it turns out we had a 419 in the past, and so some of the local jurisdictions might still have those on file, which may lead to confusion, so we changed this to 409. And we now have a complete list of all the retired numbers. We're going to make jerseys and put them around the office, so we'll know from here on out. We also conferred with the Secretary of State's office in development of this form to make sure that it's capturing all the information they need as well, and that the instructions are clear about how to submit it. This will be an additional reporting requirement for LLCs participating in California elections. We think, though, that once these people are getting to the point where they have to file this, they will have already qualified as a committee or a sponsor of a committee, meaning that they'll have many other reporting requirements as well. So they should either really have someone in-house that's dealing with this or be getting outside assistance. That said, the instructions on the form are very detailed. There are definitions defining principal officer, responsible officer, qualifying as a committee, hopefully everything they would need to be able to determine whether or not this filing is required. We'll also update our educational materials as always, and we are available via the email and phone advice lines should anybody have questions or need assistance with filling out this form. So that's
all right. Thank you, Ms. Boyd. Appreciate the presentation. Do any commissioners have questions for Ms. Boyd on the draft form? Commissioner Baker?
Thank you for the presentation. Can you say a little bit more about what educational materials will be updated, since it is new as opposed to just updating a form we've had in the past? And if we do video trainings or if it's FAQs, maybe elaborate on that, please.
Sure. I'm sure that we'll be updating the manuals to refer to this to make sure that it's in there so that anybody filing would know they need to file this as well. We will definitely, put together an FAQ, I think, as questions come in so that we can figure out exactly what people are either struggling with or having issues about. That said, as this is a brand new form, I think we are fully knowledgeable of the fact that this will be developing over time. And so as we see areas that people are having specific questions, we might come back to you to revise the form to either increase some information on the instructions so that people will be able to fill it out and not have those questions going forward.
That sounds great. I certainly would think it's the responsibility of, say, law firms and lawyers who advise these type of companies. I can still imagine scenarios where somebody doesn't figure it out on their own, perhaps. And if as you're looking at information and education materials, you might think of any partnerships where you might reach out to either associations. I know the State Bar has many different committees. They have a banking and financial institutions committee I used to be on. They have many committees that, if possible, might just see if it's even if it's just a matter of sharing the information with them, like FYI, I want to make sure members know about this. Because it's so new, that I would imagine if it's time efficient for you, look for ways to reach out to different organizations to let them know. And otherwise, it's other people's responsibility to proactively do it, but that's a little proactivity on our part.
Yeah,
Thank you.
Absolutely.
Yeah, and just on that point, I think I have the benefit of sitting with Commissioner Wilson on our Outreach and Technology Committee, so I hear about all the proactive efforts that we do for every regulation and every new form that we do. So I know that is something that we're doing on an ongoing basis, including in partnership with like the League of Cities, CSAC, other entities, CPAA. I know we have a good relationship with them. So just want to assure everybody that we do that as a matter of course for everything that we do. So thanks, Ms. Boyd.
Sure.
Any other commissioners have comments or questions for Ms. Boyd? Hearing and seeing none, do we have any public comments on item 3?
Is item 3 Stanislaus?
No, it is not. It is our Form 409 for limited liability companies.
Sorry.
It's good. Hearing and seeing no further public comment, do we have a motion to approve?
I can move.
Commissioner Wood? Do we have a second? Second, Commissioner Cardenas. Ms. Laker?
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you, Ms. Boyd. All right, we'll now proceed to item 4, and that is the stipulation regarding the matter of the County of Stanislaus, mass mailing sent at public expense. We will welcome to the dais our Chief of Enforcement, Ms. Burton.
Good morning.
Good morning.
We are presenting to you this stipulation for the County of Stanislaus. I just would like to point out that this is a mass mailing at public expense case, but this is not a situation where we have campaign materials. These were advertisements. They were actually specifically job recruitment advertisements that featured an official, which is not allowed under the Act. But this particular material, it wasn't campaign, and the official who was featured did not run for re-election. So that is why we are presenting the stipulation as we are, and I welcome any questions or comments.
Thank you, Chief Burton. Do any commissioners have questions for Chief Burton? Commissioner Wood?
This isn't a question. This is just a drafting point, which is tiny, but I thought you might want to clean it up before finalizing it, which is on page 6, the first full paragraph. We mentioned twice that the sheriff did not seek re-election. We lead off with it, and then we, in the third sentence from the end, we say it again. And so you might just want to have it in one place. That is so small. I'm sorry. I'm sorry to have even led off with that, but I wanted to bring it up.
Thank you, Commissioner Wood. Do any other commissioners have additional comments for Chief Burton? All right. Any public comment on this item?
Yes, this is Steve Petzold in Santa Clarita.
Yes, Mr. Petzold.
I read the stipulation this morning, and I was actually surprised that this was a violation. I think it was rather innocent. Certainly, police departments, sheriff's departments need all the help they can get in recruiting and showing somebody in a command position in an ad that seems fully dedicated to recruiting new officers would seem to be appropriate, if not, maybe a technical violation, but that to me would seem appropriate. I'm also concerned that it's the taxpayer, that nobody is being held personally responsible for taking these ads out within the office there, and that, ultimately, I guess it's going to be the taxpayers of Stanislaus County that are required to pay the $9,000 penalty. So given the circumstances, that there was no political advertising in the ad, that the sheriff did not run for re-election, and that it would be the taxpayers that are actually on the hook for this payment, I would ask that you consider reducing the penalty to a nominal amount, and I think that is sufficient in this specific case. And I think perhaps in your educational outreach efforts, you should contact other public agencies and let them know that this was a violation so that they don't innocently violate the regulation either. With that, I'll wish you all a Merry Christmas.
Thank you, Mr. Petzold. Any additional public comment on this item? Hearing and seeing none. Chief Brereton, I think that you did a good job on this stipulation, striking the right balance. I think these rules, they exist for a reason. These are important aspects of the Act. And I do think that the stipulation is very clear in the presentation that this does not to be inadvertent. You led with that comment in your presentation, so I'm going to move approval of the stipulation. Do I have a second?
Second.
Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. Thank you, Chief Burton. All right, we will now proceed to our, if you will, the main event for today. We do this, we started doing this in the last few years since I became chair. We have an annual Enforcement Division update. And the purpose of this is to provide information and to help educate some of our newer commissioners about what the processes are that enforcement uses, so that every month when we're presented with these stipulations, we can gain a better understanding of the work, the time and the effort that goes into those, and to provide an opportunity for commissioners to, in one sitting, ask some policy-related questions that they may have. So that is what we are doing right now. We're in item number 5. I think we would like to limit this presentation to no more than 2 hours. It's a fascinating topic. I know we all have questions. Remind commissioners you have the opportunity to ask those questions throughout the year of our executive director and the chief of enforcement. So don't feel like if you don't get to your question today, you don't have an opportunity to get to it at another time. So with that, welcome back, Chief Burton, and welcome Assistant Chief Burton. So turn it over to you guys.
Good morning, Chair and Commissioners. Thank you for having us today. As you know, for the benefit of the public, I am Angela Brereton, Chief of Enforcement. To give you a little background about me, I have been with the SPPC for 15 years, all of which have been in the Enforcement Division. I started as a Commission Counsel. I moved up to Senior Commission Counsel. I was Assistant Chief of Enforcement for about 2 years. And I've been Enforcement Chief for a little over a year. Over these years, I've handled all sorts of enforcement matters, from simple late filing violations to complex conflicts of interest and campaign contribution laundering. I'm honored to represent my staff today and to update you on the good work of the Enforcement Division.
And I'm Chris Burton. I'm the Assistant Chief of Enforcement. I've been with the agency for about 5 years now. Like Angela, I started as Commission Counsel, was promoted to Senior Commission Counsel, and I've served in the role of Assistant Chief for about a year now. Also, like Angela, I've handled all manner of cases under the Act. And in addition to my Assistant Chief duties, I do also still maintain my own caseload at the moment. And I'm happy to be here with you today.
Thank you. Please proceed. Oh, and sorry. You have divided your presentation into sections, and so my thought is that we will pause at the end of each section and allow commissioners the opportunity to ask their questions of that section at the end of each section for orderly administration of the presentation. So I think you have your PowerPoint presentation up.
Yeah,
Having some technical.
Okay.
All right, here we go. So our first topic for today is the overview of enforcement and its processes. The first topic we will discuss is the ethical wall between the Enforcement Division and the commissioners. Due process requires, in an administrative adjudication, that the decision maker be free of bias for or against any party. Bias can be either a showing of actual bias or a situation where the probability of actual bias is too high. An agency with both prosecutorial and adjudicative authority must separate those two functions to ensure the adjudicator is not biased. The FPPC is an agency with both prosecutorial and adjudicative authority, so we must separate the enforcement division from the commissioners. Taking that further, commissioners may not be involved in enforcement investigations or prosecutions except as the adjudicator. Along those same lines, if commissioners have a role in or non-public knowledge about a specific enforcement matter, the commissioner may not participate in the adjudication of that matter. Regarding enforcement cases, commissioners are prohibited from participating until the cases are presented to the commission for approval. Discussion of the cases when presented to the commission must stay within the four corners of the stipulation. Commissioners may not consider media reports when making decisions about enforcement matters. But it is important to note that stipulations are not summaries of our investigations. When we investigate matters, we spend hundreds of hours considering a wide variety of information, including documentary records, witness accounts, private information, public information, media accounts, and internet searches. We look at everything we can, but we do not include it all in the stipulations. The stipulations are distilled for purposes of adjudication. The Enforcement Division team includes intake, investigators, attorneys, support staff, managers, and the chief. There are 32 people behind every enforcement action. The Enforcement Division staff is very experienced with the Act and handling investigations. For instance, our intake manager, Tara Stock, has been with the agency for 22 years. And several of our senior attorneys and special investigators have worked in the Enforcement Division for over 10 years. Our staff is hardworking, dedicated to the mission of the Commission, supportive and good teammates, and they do their best to be fair and reasonable in their investigations, resolutions, and recommendations. To help further explain the relationship between the Enforcement Division and the Commission, I'll use the analogy of a district attorney's office. Both offices have investigators and attorneys. The investigators rigorously gather evidence. Once they gather all of the evidence, they pass the cases along to the attorneys. The attorneys are the prosecutors. They evaluate the evidence in light of the law and present that evidence, here most often in the form of a stipulation, to the Commission. In this analogy, the commissioners are the judges, the decision makers. For a judge at trial, the judge may only consider the admissible and admitted evidence when making a decision. For the commissioners, the only information that can be considered is what's presented in the stipulation. But remember, our experienced and professional enforcement staff reviews much more information than what is included in the stipulations. The stipulations presented are a small window into the investigation, not a full view. And while the stipulations are negotiated, some aspects of stipulations are not negotiable, such as admitting violations of the Act and summaries of the evidence that establish the violations. The Commissioner's duty is to avoid bias in enforcement matters, and Commissioners do this when they stay focused on the information within the stipulations presented to the Commission for approval. There's one last thing I'd like to add about our enforcement team. In 2021, we lost 28% of our team. Some were promoted, some left the agency, some were on extended leave, and others were assigned to contact tracing for COVID-19. Each loss shifted work to other members of the team, and in some instances, new members needed to be hired and trained. But the enforcement team kept moving forward, processing complaints and referrals, investigating and resolving cases, responding to Public Records Act requests, and working on other special projects. I am very proud of the good work the enforcement team does. We will discuss workload a little bit later in the presentation.
So next we're going to discuss how the Enforcement Division determines the appropriate penalties that are assessed in our cases. We look to the facts and evidence of each case, we apply the general criteria, and we look to commission direction. As to facts and evidence, it's important to remember that the penalties assessed in a particular case are very fact-dependent. Although the type of violation alone is important, the facts of each case, including the mitigating and aggravating factors, are what ultimately drive the appropriate penalty. When reviewing a case, the Enforcement Division has prosecutorial discretion to determine how the general criteria apply to the specific facts of the case, which is important because no two cases are exactly alike. For this reason, it's not possible to determine the proper penalty based on a matrix, a calculator, or a flowchart. For example, in one case, the respondent may have filed a 24-hour report late, but prior to the election, giving some level of public disclosure, whereas in another case, the 24-hour report may have never been filed. As another example, in the advertising context, one committee may have an advertisement that is missing the paid for by and committee name. However, it has a link to the committee's website. Whereas on the other hand, you may have an advertisement that is completely devoid of any identifying information whatsoever. Although these cases involve the same violation, they would likely be treated differently. We also look at the general criteria, which is provided for in the regulation, which is 18361.5 subdivision E. And the criteria are important because they are articulated by the Commission and have also been recently updated. When we apply the criteria, we typically view the 8 different factors together. But in certain cases, there are some factors that may carry greater weight, such as when we see intentional conduct. If you were to ask us, as you will see in our mainline stipulations, we always apply each of the 8 factors. One of the 8 delineated factors is penalties previously imposed by the Commission in comparable cases. We almost always rely on these comparable cases, which serve as our guideposts. And if you were to ask us where we typically start when assessing appropriate penalties, we would likely say with the comparable cases. However, although these cases serve as guides, we are not particularly beholden to them. In other words, the comparable cases are not considered precedent. Generally, we look at the comparable cases as our starting point and then look for distinctions between the respective cases that might justify either a higher or lower penalty when compared to the comparable. And we always do this through the lens of the general criteria. Again, this is necessary because each case is heavily fact-dependent. Finally, we look to the Commission's direction. In addition to the general criteria, when we assess for proper penalties, we also incorporate the feedback of the Commission. As previously mentioned, past comparable cases are not dispositive. Therefore, we also consider Commission feedback in instruction, which can change over time. The feedback of the Commission is important because it helps us set priorities and pursue our enforcement actions in a manner that meets the expectations of the Commission. There have been several examples of this recently, including direction we received to pursue specific penalties in public funding cases. There are certain violation types that typically carry a higher degree of public harm when applying the factors and based on past Commission direction. As a result, these violations carry higher penalties. Our current list, which you see on the slide, includes campaign-related communications at public expense, personal use of campaign funds, campaign contribution, laundering, and conflicts of interest. However, this list can be changed. We are always monitoring this list to ensure that it aligns with current trends that we're seeing as well as the direction of the Commission. And then the last thing I'll mention about penalties is that in some cases, there may be other considerations. For example, respondents in certain enforcement actions may also be subject to late fees and other penalties assessed by their local filing officer. It is enforcement's longstanding policy to consider those penalties when assessing our own, so that the particular respondents are not subjected to a combined penalty that exceeds what is fair and reasonable. However, these fees typically apply only to violations with lower levels of public harm, such as campaign and SEI non-filer violations. And we only do this where the violations are exactly the same. Sometimes the filing officer will waive the fees on their end. For example, the Secretary of State's office has a policy in place, which is posted on their website, where they will not charge late fees once a stipulation has been approved in an enforcement action. We also coordinate with local ethics agencies when we are both reviewing overlapping violations and work with them cooperatively. Ultimately, when assessing proposed penalties, our goal is to look at the facts and evidence of each case and apply the prescribed criteria while also relying on Commission direction, resulting in consistency in our case resolutions, which helps us to put the regulated community on notice regarding what to expect from enforcement. This next slide gives an example of how we would assess penalties within the context of a violation type that carries that higher degree of public harm, and that would be conflict of interest cases. By looking at the comparable cases that carry a similar violation, they would show us that the range for these cases is on the higher end, which makes sense because it's one of the higher degree of public harm types of cases. If there is intentional conduct, we always start at max fine, $5,000. As you see on the slide here, there's a few mitigating and aggravating factors that we will look at to see if the penalty should be adjusted either up or down when compared with the comparable cases. For example, whether or not the subject interest was disclosed on the SEI of the public official, we always look at that. And also whether or not there was a significant personal benefit received by the public official in relation to the conflicted decision. And that concludes the first section of our presentation.
All right. Thank you. Appreciate it. I had just a couple questions, and I'll turn it over to my colleagues. The first, Assistant Chief Burton, going back to the comments you made on the internal policy that we have in enforcement to not double count fines when it's the same violation at a local level and at the state level. And I just I want to make sure we put a fine point on that because I know this has come up a couple times throughout the year. As you said, this is really reserved to like late filing, unintentional conduct, where in your judgment it's fair not to double charge somebody for the same violation. Is that about right?
Right, and that's just commonly what the most common category of those complaints that we get is the SEI non-filers, the campaign non-filer referrals that we get. If they've already been assessed those fees, if they've actually paid those fees, then we will take that into consideration in our action. But yes, it is typically the lower cases that carry a lower degree of public harm. Right.
So now, because this is truly an exercise of your prosecutorial discretion in doing that, if you had evidence of an intentional pattern of avoiding disclosure, either through not filing things on time or filing things inaccurately, I take it you would exercise your discretion in that type of situation not to weigh into your consideration whether they paid a fine at the local level or not, because that is more egregious conduct. Is that correct?
We do look at it on a case-by-case basis, and as we would with any case, we would take into consideration whether or not there was intentional conduct. So yes.
Okay, I appreciate that. Thank you. And then, Chief Burton, going back to the ethical wall between the commission and enforcement, I appreciate that you began there because I think that is very fundamental to what we do. As a practical matter, though, there are times where members of the public may know that there's a case that we are considering, and they may contact a commissioner and say, hey, it seems like this has been on your docket for a long time. We haven't seen any action. What can you tell me about it? It seems to me that consistent with the ethical wall, if I received that type of a call, I would immediately transmit that person's contact information to you, and then I would step away from it because I don't want to taint or create any appearance of bias in what we do with enforcement. Is that how a commissioner should handle that type of situation consistent with our ethical obligations?
Yes, I would defer to our general counsel for a specific answer, but yes, I think that would be the appropriate way to handle it would be to refer it to me. and then I can pass it along to the appropriate staff. That way, you're protecting yourself from any potential exposure to the substance of the issues.
All right. Thank you, Chief Burton. I appreciate it. Those are my two questions. Do other commissioners have questions for Chief Burton or Assistant Chief Burton on the first portion? Commissioner Wilson?
Yes, thank you for your presentation. Kind of a technical question, Chief Burton. When it comes to someone being held personally liable versus a governmental entity paying the fine, what are the factors that you take into account to make that decision?
Who is paying the fine is not one of our specified criteria in the regulations. So that is not one of the considerations we make when we are evaluating what a potential penalty should be. We do take into account the size of committee activity when it comes to campaign reporting type violations, because we want to know how much was not reported timely. But other than that type of scenario where, the amount of the activity coming in is relevant to a specific criteria that we have, whether it be in the Streamline program or in our general criteria in the factors for figuring out a penalty for mainline cases, we do not take into consideration who is paying.
There are scenarios where someone might be personally liable, but those are limited.
Yes.
Is that correct?
There are situations where officials are the only named respondent. Conflict of interest violations, for instance, they are personally liable for that violation. Most oftentimes when there's a statement of economic interest violation as well, Form 700, they are personally liable. So yes, we do have those situations.
Okay. Thanks for the clarification.
Certainly.
Commissioner Baker?
I do, but I think Commissioner Wood was raising his hand.
Oh, sorry. Commissioner Wood, go next.
My question's pretty brief. I wanted to just thank you both for doing this, and Chief Burton, you're so wonderful. I can tell how much you love your staff, and I also really got a sense that it's been very tough this year, and so I just want to thank you for all that you and Assistant Chief Burton are doing. We're very lucky to have you in California. My question right now is very small, which is kind of along the lines of the ex parte communication stuff that Chair Matich was asking about. So if that happens, which of course it hasn't happened to me yet, but if it were to happen and I were to send it to you, is that basically cured by putting it on the record? Is that how we do that? Or maybe that's a question for the General Counsel. But basically, if you were to receive information from us, does it go in the record that there was an attempt to contact us? You may not know. I'm sorry.
I am going to defer to our General Counsel, Dave Bainbridge, on that one.
Bainbridge?
I was told I had this month off. Yeah, that's correct. You should put it on the record at the next meeting if you receive such a contact. That's the general cure for ex parte communications, is put it on the record so that everybody knows that it occurred. You can't stop someone from coming up to you at a party and starting to talk to you about their case. So if it happens, contact me, contact the chair, let us know, and we can put it on the record at the next meeting, and that should cure the initial communication itself. And this is all covered in the Commissioner Code of Conduct too, if you want more details on it.
Thanks.
All right. Thanks, Commissioner Wood. Commissioner Baker?
Thank you. I echo Commissioner Wood's, really pleased to see how much you care for your staff and are proud of the team. It's good when that happens in any agency, and it's just very reassuring, and of course, expect to see it. You mentioned a figure of losing 28% of the enforcement team in 2021. And this may come later as we're talking about where cases are and more workload. How does that compare to 2020? Because we also had contract tracing happen. Has this been like a 2-year experience that you've had as well?
I didn't actually calculate the numbers for 2020, but that is true. Some of these losses did span 2020 and 2021, especially with the promotions, the extended leave, the COVID-19 contact tracing. All of those things overlapped both of those years. So, and we have had new hires in both 2020 and 2021 as well. So that does, so yes.
And is our staff no longer redeployed to contract tracing? Is that still happening? Okay. I saw Director West nod her head, but I'll leave that one for you, just so we know where we're at in that part.
We currently do not have anyone in enforcement doing contact tracing.
Got it, yeah. And then the only other one is I very much appreciated addressing the question of when there are consideration of fines from other agencies. Because, you know, we really grappled with, I think it's fair to say a stipulation over the summer where that popped up, the issue that another agency, I can't remember if it was criminal, like a prosecutor's office, it was the Blue Pack step. And we really were grappling, all of us, I think, with what to do and what to consider. And if it's a criminal agency versus, and there's been criminal penalties that have been potentially exacted, does that weigh into your decision-making differently? Certainly we were talking about, I think I don't want to say run-of-the-mill, but lower-level fines might be a consideration. But how does criminal penalties come into it? If you can say more about that, please.
Yes, criminal penalties are treated much differently. We defer to criminal action. So if there is a criminal action pending and it's related to the same issues that we have in our complaint, we will not pursue that case. Well, it depends when we get the case. We'll go into some of that procedure a little bit later in detail, but as far as criminal activity goes, we defer. So we do not pursue administrative penalties for the same violations that are pursued criminally.
Does that affect our statute of limitations? So let's say something's going on criminal-wise, and we may want to continue administrative action. Do we have that told? How does that work out?
So I'll expand on your first question a little bit first too. As there is a statute that also requires us to defer for criminal activity to not pursue an administrative penalty at the same time. And I apologize. Can you please restate your second question?
Sure. Gosh, I hope I can remember the second question. If anybody can remember my second question, it was mostly, I think I was getting to when we are considering criminal matters and how it affects like a statute of limitations. And I'm kind of imagining a situation where the criminal prosecution goes forth. We're not at the same time going to do administrative action, but there might be other elements that in the end, perhaps you choose to go forward with. Maybe they aren't part of the criminal settlement in the end or otherwise. Is there a stopping of the statute of limitations during the criminal part, or do we have to seek an agreement with the respondents on that?
Correct. We would have to seek an agreement because there isn't an automatic tolling of the statute just because the criminal violation is being pursued by a law enforcement agency. We would either have to issue a probable cause report or enter into a tolling agreement with that party in order to toll the statute on anything that we wanted to pursue. If it were getting, to the point where we were close to the 5 years. The criminal statutes of limitations are shorter than for our administrative action. So sometimes there isn't a problem when the criminal action is resolved or they've decided, they're not moving forward, or they're not pursuing the violations under the act that we would be pursuing, then we can move forward. So we would have to treat it just like any other case as far as the statute of limitations goes.
Got it. Oh, there was the last one, but I don't want to. Yeah. This is on a different point. So.
Okay. Well, let me ask my follow-up then. Chief Burton, I just want to make sure I understand, because I understand your general point about the statute and us deferring when there's for a criminal prosecution. And so when we refer or defer to like the Attorney General for a criminal prosecution that arises out of something, an investigation that we may have done into the act, my understanding is that through interagency cooperation, that they will seek as part of any plea deal or final resolution fines for those violations of the act. So we may not be pursuing it administratively, but through the criminal proceedings, there would be some recognition of the violations of the act and some potential for a penalty. Is that a correct understanding?
Yes, there's also, yes, we do work with the law enforcement agencies as well. And so sometimes the plea agreements, if there is one, will include the criminal activity as well as penalties for violations of the act. And if they're not pursuing those penalties criminally, we'll have a stipulation that goes along with that plea that is an administrative action on our end, so that the violations are still being pursued and in conjunction with the criminal action, but not under the criminal authority. So we've had several stipulations where we've brought that situation to you for approval previously.
Right, and I think that's important because it's really, we're talking about more of a sequencing and who gets priority for prosecuting the illegal activity. We're not losing out, or the act is not being enforced because of the criminal proceeding. It's just coming under the auspices of that proceeding as opposed to being presented to us as an ordinary administrative action, right?
That's correct,
okay.
Yes.
I just want to make sure we clarify that. Executive Director West. Did you have any other?
Pardon me, I have one correction to make. So the statute specifically precludes a civil action if there's criminal action pursued. It does not specifically preclude administrative action, but it has been our policy that we do not pursue administrative action at the same time as a criminal action is being pursued for that same violation. But with the caveat being, we will work with the law enforcement for any resolutions that may cross both and find a resolution that way.
Right. Thank you, Chief Burton. Commissioner Bacon?
Thank you. Before I go to the last one on this sort of segment, I'm, perhaps because I'm from Contra Costa County, I'm mindful of the Mark Peterson and Joe Cancimia case. And the Cancimia case came up earlier in this year, where that was a criminal matter, if I remember correctly. They were criminally prosecuted, but also they did pay fines to us. Were those are those examples of how it was sort of staggered, or were they concurrently pursued? The criminal and our own administrative work, I don't recall.
Yeah, I'm going to defer to our Executive Director, Galena West, on that, because she was the enforcement chief during the time of both of those cases.
You and I have almost a one-year anniversary happening. Thank you.
Yes, the historical perspective, I think, is my job. So basically, in those cases, it was our case that happened first, where we actually exposed the violations, and then the violations, once exposed, were then picked up by the criminal law enforcement. So sometimes it happens that way, where we're not getting a lot of interest, or the violations, when you see a complaint or an audit, you're not really sure what it's going to be. And so then after our investigations and our investigators pull all the strings and get all the information, then it can go on to a criminal prosecution. So it happens in a variety of ways. So the timeline's not set or static.
Very helpful. Thank you for both clarifications. The last one goes to the issue of both precedent in STIPs and when we're potentially adding counts. Because back in September, we had a stipulation. I don't remember which one it was, but we started addressing the question of when your team may combine counts into one count. And when we had asked about, what are the criteria you use to determine when you do that, there was a mention of, well, in prior STIPs, this is what we've done and how it played out. That's why I'm trying to understand the role of precedent or not that comparables play in either what the fine should be or whether you even charge something as a separate count or multiple counts. because that, of course, can affect the maximum penalty. Can you elaborate on that last part of how much, I keep wanting to say precedent, how much prior steps may influence when you combine counts as opposed to have individual counts?
So when we're using a comparable case, we are using it as a guide, so, telling us this is how we have done it before. But our staff uses their judgment and experience in dealing with other matters as well as the one that they're looking at to say, how do the facts and circumstances of this case relate to the comparable case, and what is fair for this case in light of the comparable case? So that might be that we have a comparable case that combined 8 different campaign statements into one count, but this was activity that otherwise would have been in the Streamline program, but it was a little bit over the thresholds, so it didn't qualify. Whereas the case I'm looking at right now, it involves some intentional conduct where people were purposefully not filing those campaign statements. We're going to treat that much differently than the comparable case. But the comparable case gives us a place to start. And we look at several different comparable cases, too, to kind of get a range of, like, where the activity lies. So it's correct to say that it's not precedent, meaning, like, we don't have to follow the comparable cases exactly to the T. But we want to stay within a range and be able to articulate how we're changing from that range, if we are, based on the facts and circumstances of the case that is before us.
Thank you. That's been hanging out in my mind since September, so I knew this day was coming. I'm grateful to know. And again, thank you for the pride you take in your team and work that you do. It's great to see, and look forward to the rest of the report.
Great. Any other questions for Chief Burton or Assistant Burton on this portion of their presentation? Hearing and seeing none, please continue.
Okay. So our next topic is our Streamline program. So this first slide is a refresher of the comparison between mainline stipulations and streamline stipulations. Mainline stipulations include a full factual summary. They're typically higher penalty amounts, and they are approved by the commission. Our streamline stipulations are form stipulations. They use specific commission-approved criteria in the regulations to determine the penalty amounts, and the enforcement chief is delegated the authority to approve them. The Streamline program was a policy decision by the commission to create flexibility for the enforcement division's resources. The Streamline program allows enforcement staff to resolve straightforward, lower public harm violations and spend more staff time on complex, high public harm violations as identified by the commission. In 2021, the Streamline program received some significant updates. The goal of these changes was to make the Streamline program more inclusive. First, the qualification thresholds were broadened. The base level of the population-based thresholds were raised to include more violations occurring in smaller jurisdictions. Also, the penalty structure was changed to include a Tier 1 for the lowest level public harm violations and a Tier 2 for mid-level public harm violations. Along these same lines, general chief discretion was added to include or exclude any matter in the Streamline program. And specific factors for chief discretion were added for excluding counts or for raising penalties. The commission made these changes to include more lower-level public harm violations in the Streamline program, including bringing some mainline violations into the Streamline program. Along those lines, 2 new categories were added. Major donor committee campaign statements were added to better address the violations for this type of committee. And behested payment reports were also added, since the late filing criteria for campaign statements didn't apply to these types of reports. And bringing behested payment reports into the Streamline program allows the Enforcement Division to resolve these late filing violations consistently with other lower public harm late filing violations. However, the Enforcement Division will pursue mainline penalties for more egregious behested payment reporting violations. The new Streamline Program regulations have been in effect for 8 months. So over this time, we have seen an increase in the amount of streamlined stipulations compared to mainline stipulations. Through November 30th, 2021, 86% of settlements were streamlined. Compared to 2020, 70% of settlements were streamlined. So this is a 16% increase for the updated Streamline Program's first 8 months. So the goal to make the Streamline Program more inclusive is working. We will continue to evaluate the Streamline Program's progress and report back to the Commission at the end of the year, next year, after the full regular election season has completed. That's everything for, for Streamline, sorry.
Great. Thank you, Chief Burton. Do commissioners have any questions for Chief Burton on the Streamline Program? Commissioner Wood, did you have your hand up? Nope, sorry. Commissioner Baker?
Thank you. Really helpful. I guess I'm asking you to take not a 10,000-foot view, maybe 30,000-foot view. Now there's been some more experience with streamlining. Are there any other impacts that you find that it's happening? Is it enabling that you're seeing among the team? Either workload is, I know we're going to get into a little bit more of that, is going faster, or it's freeing up resources for other things, or any other observations that are helpful for us to know about streamlining beyond the numbers, just from your observations this last year and a half of it happening?
I am seeing more of the streamline cases coming before me, and it is, as far as my review and approval goes, the Streamline Program cases are much faster for me. So I imagine that it's much faster for staff as well. So by increasing the pace at which we can move cases, it does, in theory, it frees up more time for us to be doing other things. We haven't collected all of the data available yet, and we're hoping to get some really good data after all of the elections next year, to be able to really make some good recommendations with, as to, this is what's working, this is what isn't. That's our goal for 2022.
It sort of sticks out in my mind that at the same time period, roughly, where you've had 28% fewer enforcement teams, you've had more settlements go through Streamline, and I realize it's not quite apples and oranges, but it is good to have been able to be more, I don't want to say efficient, but streamlined during a time when you have fewer staff. So thanks for that bird's eye view.
And I'll just tell you, as an attorney that currently maintains his own caseload, that the effort that goes into preparing a case for a streamline recommendation versus a mainline is significantly different, and it definitely makes things more efficient.
Any other commissioner questions for staff on the Streamline Program update? Hearing and seeing none, please continue.
Okay, our next topic is the Enforcement Division's pre-election outreach program. In order to meet the Commission's objective to promote transparency in government, and given the elevated interest in disclosure prior to an election, every election year, the Enforcement Division undertakes certain proactive efforts to ensure that candidates and committees participating in the election are meeting their obligations under the Act. Although these efforts increase our workload and shift our priorities during election years, it is a task that we take on enthusiastically, and it is something that we are very proud of. Our pre-election efforts impact everyone in enforcement. Our intake staff handles what is typically a deluge of election-related complaints and makes recommendations on how to proceed. Our investigators review AdWatch submissions and move quickly to investigate all manner of urgent election-related matters. And attorneys make efforts to gain compliance, work urgent cases, and at times file for civil injunctions. For the past 4 election cycles, we have carried out this program and with great success. As you see on the slide, these efforts include ensuring that campaign statements are filed by committees before the election, identifying the sources of political advertisements, and quickly resolving election-related complaints. In terms of ensuring that campaign statements are filed, enforcement coordinates with local jurisdictions to bring their filers into compliance. supplying an important resource to local offices in advance of an election. This typically involves extensive communications with the non-filers by enforcement staff. To put a finer point on it, participating jurisdictions will supply us with a list of who hasn't filed their statements, and then we contact them to bring them into compliance. In 2020, we contacted the clerks in all 58 counties and cities with a population of 100,000 or more, as well as any cities who asked for our assistance. This resulted in 91 counties and cities participating in the program. In advance of the primary election, enforcement reached out to 103 different pre-election non-filers, meaning candidates and committees who did not timely file their pre-election statements. And we achieved almost 100% compliance before the election. Before the general election, we reached out to 239 pre-election non-filers and again achieved almost 100% compliance prior to the election. On rare occasions where we are unable to gain compliance voluntarily, in the past we have also used the tool of filing a petition for injunction in the civil courts to require that the committee file their statements. And we did this once in 2020. In terms of advertisements, our compliance efforts on that front seek to cure any advertising violations that come to enforcement's attention prior to the election, with the priority being ads where it is unclear who the source is. Since 2018, our new AdWatch program has served as a useful tool that communicates to us ads that may be non-compliant. In fact, in 2020, we had 185 AdWatch submissions submitted from the public, many of which led to a finding of violations. And then finally, with our proactive efforts, we will typically try to resolve complaints prior to an election given the elevated public interest. This can be difficult given the tight timing, which is why we, at the very least, try to get compliance so there is some level of public disclosure of the campaign activity prior to the election. In other words, we focus on the things that we can do before the election. Where possible, we try to expedite warning or advisory letters, the presentation of stipulations where there's time, and rejecting complaints. This can be a challenge as the number of complaints inevitably goes up right before an election, but we always do what we can. To give you some perspective on the volume we typically see before an election and how quickly we move to resolve complaints, during the time period in 2020 between the March primary and the November general, we received 978 total complaints, and 492 of those were rejected. Of all the complaints that we received in 2020, 33% of them were resolved on either the day of receipt or within 1 day. 51% were resolved within 7 days, and 83% of the complaints were resolved within 30 days. Now, the last thing I'll note is that following each election, we always debrief and deconstruct how things went. We look at where we succeeded and where there might be room for improvement, and we're constantly enhancing and improving our program for future elections. And that concludes that section.
Thank you, Assistant Chief Burton. I thought that was really helpful. I just want to take another opportunity to commend staff on all the work they do on the pre-election outreach, because it's, you know, that is really, you get a spike in workload and you have to essentially set aside or focus on that for a fixed period of time and then still maintain your normal caseload as you're doing that. So, I mean, I get the advantage of, I can see staff on a day-to-day basis during an election year and how sort of frenzied, controlled frenzy, they can be during that period of time. But it really, you guys do fantastic work with that program, and the public benefits greatly by expediting the resolution of those cases before an election. So just thank you, and thank you to the staff for the hard work during that period of time. Do other commissioners have questions on the pre-election outreach program? Commissioner Wilson?
I just want to reiterate what Chair Matich just said. I had the benefit of working here, not working, but serving on the commission starting at the end of 2019, you know, through the 2020 election. And the work that the Enforcement Division does is extraordinary. You know, this PowerPoint presentation reflects the countless hours that you put in on a daily basis and throughout the year. So, you know, Chief Brereton as well as Assistant Chief Burton and your entire operation, thank you for all your hard work.
Thanks, Commissioner Wilson. Other Commissioner Baker?
Thank you. Just echo well-deserved sentiments. And also 2 questions. One is about AdWatch, and then one is about pre-election communications on matters. On the AdWatch one, you mentioned 185 submissions. Can you just give me a point of reference, like perhaps in the prior year it was half that? I'm just kind of curious if we're on an upward trajectory, if it's pretty flat. I have curiosity.
We're actually going to get into that later in conjunction with the recall, but I can tell you as a preview that in 2019, we actually did not have AdWatch live. We took it down in between elections. In 2021, we did have it live, and I'll discuss those numbers in conjunction with the recall discussion.
Got it. Great. Thank you. And then on the pre-election communications, because it can be also, I think our agency may be subject to criticism or, who knows, praise, depending on who likes it. If leading up to something, there's quick disposition of one election-related candidate or matter, and maybe there's a longer one. That happened kind of in the recall, where there was one that was turned around in one day of rejection and another one was open longer. And I just want to say I understand there are these, it's important for the public to know there's standard practices, there's policies on these things that you're trying to comply with fairly. But it did raise one of the questions, do you also try not to release what could be, I don't want to say detrimental, but information about a case leading up to an election because it could have an impact on that election? And the only example I can come up with, and I'm sorry it's a politically charged one, is before the 2016 election, whether or not the FBI decided they were going to open up an investigation into one of the presidential candidates 2 weeks before. If, for example, you reach conclusion of a matter for someone who's on the ballot, and it could be that they're going to pay fines, do you wait until after the election to make that public so it doesn't have an impact, or does that weigh in at all in your pre-election, not so much outreach, but communications?
We try to do as much as we can before the election that we can with the timing. Settlements do take time, and so sometimes it's not possible for us to get that information before the public. But we do, if it were a Streamline case, for instance, and we were able to reach an agreement with the parties, we will move forward before the election to get that information public. So it depends on the circumstances, but we will do what we can to get information to the public that is appropriate to be disclosing to the public.
Got it. Is it another way of saying that it's whether or not that person or that entity may be on the ballot in 2 weeks, that is not one of the factors that you take into consideration? For example, if somebody's about to have a penalty, maybe wait on them in a stipulation. You don't time it based on, it's 2 weeks before the election, or you do? We try to get the disclosure, if it's something concerning the election. So for our pre-election efforts, it's all about getting the campaign activity disclosed before the election. If we can also bring that case to a resolution before the election, we will do so. Gotcha.
But one of the pre-election statements is due 2 weeks, 16 days before the election. So that's not usually enough time for us for those types of cases to get anything, because we have certain timing requirements for our agendas and things like that. So in those cases, we'll try to get them heard before the public as quickly as we can after the election occurs. But so for most of our pre-election efforts, we can do things like warning letters in advance. Even if we find that there wasn't a violation, we can get that information out as well. So we do as much as we can, but the timing is very tight for pre-election activity.
Great, thank you.
Chief Burton, just to kind of tie that last point up, because I think it's very important for the public to understand this, but the potential political ramifications of a finding by the Enforcement Division that a violation has occurred has zero bearing on our timing in releasing that publicly. We are concerned with doing justice and with ensuring that if a violation has been found, that the resolution is completed, if possible, before the election. Whether that has political consequences or not isn't really our concern. That would be, in fact, in my view, inappropriate for us to take that into account. Is that correct?
That is correct.
All right, I just wanted,
Thank you. That was a little bit my,
thank you.
If you imagine that any election year, you could get criticized for one way or the other, and it's not a political consideration.
Right. Any other questions for, Chief Burton? Sorry. Hearing and seeing none, we'll go ahead and proceed.
Okay, our next section is a recap of our 2021 workload. The Enforcement Division's workload is driven by complaints and referrals, working open cases, responding to Public Records Act requests, and other miscellaneous responsibilities. Complaints and referrals are where the bulk of our workload begins. We get complaints as sworn, non-sworn, or anonymous complaints. We get referrals from filing officers and as audits from the FTB and the FPPC's Audit Division. We also open cases as staff-initiated matters based on media reports and tips and referrals from law enforcement agencies. Now, as a quick refresher on how the intake process works, all of our complaints and referrals go through the intake process first, and they're handled by our hardworking intake staff. Intake makes a recommendation to the chief whether to open a case for investigation and possible prosecution or whether to reject the complaint. A case is opened where the initial review identifies sufficient evidence to merit further investigation. If a case is opened, responsibility for the matter then either stays with intake staff working under the direction of the chief, or it shifts to a case attorney. And if it requires a full investigation, then it also is assigned to a special investigator. Where necessary, enforcement may also add other support staff to cases or request assistance from the Audit Division for additional support. If violations are found, the case proceeds to administrative prosecution and/or settlement. Enforcement also has a duty to respond to relevant Public Records Act requests that are submitted to our agency. Our support staff and commission counsel attorneys are the ones who typically work on these responses throughout the year, and the necessary effort at times can be significant. Finally, enforcement undertakes special projects throughout the year, such as our proactive laundering program, and also recent efforts to make documents ADA compliant. We're also always onboarding and offboarding personnel and conducting ongoing trainings of new and existing staff throughout the year. Generally, enforcement's workload can fluctuate between election years and non-election years, not necessarily in terms of the size of our workload, but the type of work that is being done and the different priorities. For example, in election years, we tend to see heavier complaint volume, and in non-election years, we tend to see more referrals come in. In 2021, this year, that regular cycle was disrupted a bit due to the gubernatorial election, recall election, and we do also regularly work on other special elections across the state. And we will discuss the recall election in more detail later in the presentation.
This slide shows the number of complaints and referrals received each year since 2017. As you'll see, the 2021 numbers, they're through November 30th, so we don't have the full year yet. Our numbers for complaints and referrals received are in line with what we have seen for the past couple of non-election year election years, which were 2017 and 2019. This slide shows our complaint processing time for 2021, which, as I said before, was a non-election year. The median days open was 14 days. To clarify, these are the processing times for complaint resolutions. So complaints with allegations of violations of the Act come in, and if they contain sufficient facts or information to pursue an investigation within the FPPC's jurisdiction, they are opened into cases to be resolved. So complaints that do not allege violations of the Act or lack an evidentiary basis for finding a violation of the Act are rejected. But both of those are considered complaint resolutions, whether we open into a case or whether we reject it. The complaint is resolved at that point. And this slide breaks down the processing time a little bit further for 2021. So again, this is through November 30th, and complaints resolved on the day of receipt or within 1 day, we had 17%. We had 33% resolved within 7 days and 72% resolved within 30 days. We anticipate an even quicker complaint processing time in 2022. The enforcement team and primarily our hardworking intake team will begin our proactive pre-election program in 2022. And our pre-election focus drives quicker processing times for complaints to get disclosures before the elections. So this slide shows the average number of cases open in a given year. So to clarify here, this is talking about cases. We receive the complaints that allege violations, and when our initial review of the complaints identifies sufficient evidence to merit further investigation, we resolve the complaint in our database and we open a case in the database. And our database uses different types of numbers to identify complaints and cases so that they are easily distinguishable in our database. This chart only shows the average number of open cases. As you can see, our average number of cases open in 2021 is on par with the average number of cases open in 2019 and 2020. The jump between 2018 and 2019 can be attributed to an expansion of the Political Reform Act, partly due to the Disclose Act that was brought into effect. It considerably expanded the disclosure requirements for political advertisements, and we received a jump in complaints as well as then cases open. We have also experienced an increased volume of local filing officer referrals in 2019, which also added to the enforcement division workload. Staying on the same line of cases, this slide shows our case pendencies through November 19th, 2021. So the days open median on the left encompasses all violation types. The list of violations in the chart is a selected list of violation types to give you a flavor of the different pendency numbers as it relates to violation types. We will be compiling a case pendency list for our 2021 annual report to the legislature, which is a much more detailed report, and that will be available in mid-January. As you can see here, less complex violations, many of which are included in our Streamline program, tend to resolve faster. More complicated violations take more time. You'll notice that campaign bank account violations are the lengthiest here. Recipient committees hold funds in trust for the persons who make contributions to the committees. In other words, committees use other people's money. So the Act requires committees to use a single campaign bank account so the campaign money is not mixed up with personal funds. So when we have potential campaign bank account violations, it is important for us to trace the campaign funds to make sure the funds are used lawfully. The only way that we can do this is through our subpoena power. Campaign bank account violations often involve issuing subpoenas for several different bank accounts in order to trace the campaign funds and prove the violations. This is a lengthy process because the subpoenas produce a significant amount of records to review and analyze so that we can recreate the campaign's accounting. The subpoenaed records often lead to other entities or witnesses which require further follow-up and investigation. Issuing subpoenas for bank account records is also a two-step process on the front end. First, we must personally serve a notice to the customer, the signatory on the bank account. Once that is served, then we can serve the bank and receive the records a few weeks later. But there can be issues with serving the notice to the customer, such as when the person is uncooperative or avoiding service, as well as when the signatory on the account is deceased or otherwise unavailable. This is one of the reasons why our proposed legislative change to increase the transparency of committee bank accounts is so important. Better transparency and having more responsible signers for campaign bank accounts will help us to serve these types of subpoenas faster and trace the campaign funds sooner. When we issue subpoenas, we must take care to keep them narrowly tailored in scope and time frame to obtain the information we need and not be overly burdensome for the subjects of the subpoenas. We also need to be mindful of our jurisdiction. For instance, we do not automatically have jurisdiction to subpoena personal bank account records. Yes, sorry. We do not automatically have authority to subpoena personal bank account records, but we can subpoena personal bank account records when we have sufficient grounds to suspect that campaign funds were deposited into a personal bank account. Other factors contribute to lengthy investigations as well, such as uncooperative witnesses and respondents and cases that go to an administrative hearing. We realize that some cases take more time, and respondents and complainants want to know what is happening in their cases. We have not historically provided specific guidelines for enforcement staff for communicating with respondents and complainants regularly throughout their cases. But we are looking into ways we can improve the frequency of communications with respondents and complainants.
And then finally, in terms of our 2021 workload, we did have a bit of a curveball thrown our way with the gubernatorial recall election, which took place on September 14th. Heading into the election, we weren't quite sure what to expect, since the last one of these was in 2003. But we prepared for the election with the same focus that we would give any primary or general election. Ultimately, we ended up receiving approximately 50 complaints that were related to the recall, 8 of which originated from submissions through our AdWatch program. Of the 50 complaints, 36 of them warranted further investigation and were opened into cases, and 14 of the complaints were rejected. In 2021, as mentioned, our AdWatch portal remained live, and it has generated to date 20 submissions. And of those 20 submissions, 40% of them were related to the recall election. So as you can see, the number of AdWatch submissions was lower in 2021. As a reminder, it was 185 in 2020. But we did anticipate this since it was an odd year. And also, this was the first non-election year that we kept AdWatch open, as it was not operational in 2019. In terms of proactive outreach efforts in advance of the recall, the one thing we did was we ensured that all of the replacement candidates complied with the candidate SEI filing requirement, which resulted in almost 100% of the candidates on the ballot filing their candidate SEIs prior to the election. And that concludes our workload recap section.
Great, thank you. Quick question, you just mentioned the AdWatch numbers from 2021. I think you said 40% were related to the state gubernatorial election. So it begs the question, the other 60%, were those local races? Were there other state legislative races? Like what comprises the rest of the 60%?
I think it comprises other elections that are going on, such as special elections during the year. There are also, we do see submissions at times that come in after the election has transpired. So I think some of those may have been carryovers from 2020. So I think that's the composition of the remainder of those.
That's great, thank you. And then, Chief Burton, I wanted to go back to, on my printout, it's page 14. It's the complaints and referrals received as of 11/30/21. And 2019, compared to other years, seems to be kind of an outlier. 1950, and again, this is complaints and referrals, this is in cases, right? What's coming in. 1950 in terms of the referrals, 744 in terms of complaints. I'm just curious, because it doesn't appear that spike has repeated itself. So was there something unique about 2019 that led to that?
As far as the referrals go, we received an extraordinary number of referrals from local filing officers that our staff refers to as bad referrals, meaning they did not include complete information. So and some of them were old, some of the, it happens sometimes where a new filing officer comes in and wants to clean the books, make it all new, and so they send it all our way, but they don't necessarily make sure that all of the information is accurate. So that was we had one county in particular that sent us hundreds of referrals that year, and many of them have had challenges to them. So that accounts for the spike in the referrals. As far as the complaints, it appears that the Disclose Act probably was, one of the issues that increased the number of complaints coming in. But we don't have other data specifically on the complaints.
Thank you. Those are all my questions. Do the commissioners have questions for Chief Burton? Commissioner Wilson?
This is more out of curiosity in terms of, because you referenced there are some cases that are filed anonymously, correct?
Correct.
Now, when you say anonymous, is it confidential to you and your staff, or is it just anonymous across the board, so no one, not even your staff, knows where the complaint comes from?
It is anonymous. We do not know who the complainant is, which can lead to challenges if we have questions about what's included in the complaint. If there's a complainant there, we can reach out and get some clarification, and maybe that helps us to decide how we'll resolve that complaint. But when it's anonymous, we don't have anybody we can reach out to. So that might mean that we would have to reject a complaint because we can't get further information about it, and on its face, it's not going to give us enough.
Right, and I'm not asking for you to do any additional research, but, I mean, roughly, are there a lot of anonymous complaints, or would you say that it's relatively small percentage? I would assume it's a small percentage, but I'll defer to you on that.
I do not have any specific numbers. So I would have to have my staff calculate that. My impression is that we have more sworn and non-sworn complaints. A non-sworn complaint is when it's not a sworn complaint. They're not signing under penalty of perjury, but they do identify themselves. So we have more on that side where we have a complainant identified than we do where there's no complainant identified.
Just for clarification, I'm not asking for that research to be done.
Okay.
It was just a general question to get a sense. Your response was very helpful. Thank you.
Great. Other questions for Chief Burton, Assistant Chief Burton? Commissioner Baker?
Thank you. I have some questions related to workload and what tools would be helpful that we can know about. You mentioned one of them, and we're already pursuing it as a bank account related matter. And some questions separate from that. On the separate side, it sounds like you turn the AdWatch app or program off at times. Why do we do that? Because I'm wondering, it seems like during the year someone may have they seek an ad that comes from a school district that looks like they're using public money and they want to upload the ad that they get. I'm just curious what the turnoff is about.
Well, that's actually, let me just jump in.
Oh, please.
That was historically what had happened. And this year, in discussing it with staff, and particularly Chief of Enforcement Burton, Executive Director West, we determined that for exactly the reason you just alluded to, it would be a good thing for us to maintain that part of our website.
Got it. So
that, as you point out, when you have, local off-state election year races where there may be a misuse of public funds ad, that's an easier way for the public to inform us of that so we can pursue it. So
there you go.
Good
quick answer there. Hey, thank you. So already took care of that one. And another one I have goes to one of the graphs is about how quickly cases come in and how they're disposed, and which is great. It sort of reminds me of when Mr. Bainbridge was mentioning how quickly the staff is responding to advice letter calls or advice line calls. It happens so very quickly. It's a great track record to have. I'm curious, how many of those fit into that category of this isn't even a violation of the act at all? Like, we get asked sometimes in media questions, the Brown Act has been violated. Well, we don't have jurisdiction over the Brown Act. Can you give us some, even if it's not specific data numbers, a sense of the ones that are able to be quickly disposed of, what proportion of them are not even within our jurisdiction at all, even if they had been true?
I don't have specific data on that, but that is a very common reason to reject a complaint quickly, because my intake staff is very good and they identify those issues very quickly. My intake reviews every complaint that comes in, and aside from extenuating circumstances, most of the time their review happens immediately, and so they send what they have to me as quickly as they can. So, when it's a issue that's not included in the act, it's a simple calculation for us to make whether we open or close.
Sure.
So that one can be resolved very quickly.
Yeah, I was curious because I just know, of course, it would be perfect to be able to dispose of this quickly, but how much there is a reliance on us for things that are outside our area of jurisdiction. The Brown Act is the first one that pops up to mind. Another question I have goes to, we get reports once a month on how many cases have opened and closed, and we see good information about that from you. I've been curious if there's a way to get a report, maybe it's quarterly, maybe it would be easy to do monthly once it's set up, on the age of cases, a snapshot in time. For example, we have, the bulk of our cases are less than a year old. Maybe it's, I don't know what benchmarks to set, but I would be curious about them. Also, as a way to be tracking how things are going age-wise. But say when Streamline comes up, we'll be able to, that might be a data point a year from now that'll be helpful to have. Is it possible, at least quarterly, if not monthly, in the report you already provide, to have some sort of, here's how many cases are this old, that old? Is that doable and without much administrative time deflected from investigations?
So can I just jump in? I think we already talked about, with respect to Streamline, having that at the end of next year.
Yeah.
I think that makes sense from an efficiency standpoint. I know that Chief Burton put in place some new procedures in the Enforcement Division recently to track workload and things of that nature. And so I think having a mid-year report next year and then updated numbers as part of the annual report makes sense from an efficiency standpoint, bearing in mind that we're going into an election year.
Yeah.
And Chief Burton and her staff, which we already know is short-staffed,
Yep.
already has a lot on that plate. So I think that makes the most sense from an efficiency standpoint. I don't know if you agree with that or not, Chief Burton. It seems to me that's probably about right.
I think that timing would work. I will need to determine whether this is information that we can gather efficiently.
Mm-hmm.
Our database is great, but it does have some limitations. So some of the calculations that we bring to you are actually done manually rather than through our database.
I wondered, yeah.
So it may not be, I will need to review to determine whether or not we have the resources to do that type of calculations.
Thank you, and certainly agree that at least mid-year would be helpful to get a snapshot in time of what are, help me to understand, what are the ages of some of our cases. If it doesn't require, so many man-hours, I'd love to see it quarterly myself, just to see where it's at, regardless of the streamlining part. So I'll wait to hear back from you on what is really feasible so that the team can be focused on the work itself as opposed to just data points on the work. Always important. And then another question I have goes to statute of limitations. A couple times in the last 6 months, there have been stipulations that have come before us that are close to the statute of limitations. And as I recall, for reasons totally beyond our control, a criminal matter might get referred to us 2 months before the statute of limitations, which doesn't leave our team with very much, or maybe that's when the complaint is filed. One statute of limitations expired on a matter that I was given the closure letter. It's public on our website. And I wanted to inquire, do we have mechanisms in place to track when a statute of limitation is about to expire? Because in the matter that was put public on our website, it was in the Stollard matter, there was a closure letter that mentioned the complaint was filed in, this is all publicly available information, in April of 2019, and because the statute had expired, there wasn't going to be further work on it. Do we track when, I mean, obviously that's not ideal. I mean, if we want to pursue a case, we don't want the statute of limitations to tie our hands to do that. Do we track when cases are getting there? Because it is a surprise when a statute expires before we've been able to take action. And you've already highlighted for us in the last year, you had a lot fewer staff, and of course, some of them were deflected to COVID. Can you address that?
Yes. We do keep track of the statute of limitations as best as we can with the information that's available. Sometimes we don't get that information immediately from a complainant. So once we know or we can determine what a reasonable, sometimes statutes of limitations are not easily discernible either from the activity right away. So we do our best, and we do keep track of that. But our caseloads are very high right now for our attorneys. Some of our attorneys have upwards of 95 cases. So unfortunately, occasionally things slip through the cracks, and it's very rare, but sometimes it unfortunately does happen. We do keep track, and most of the time we do not have an issue with that. We are keep informed of it, we're keeping on top of it, and we're making sure that we're doing what we need to do to make sure that that statute is told if we're getting close. Okay. So it is very rare that we are not able to pursue something.
I certainly haven't seen it except this one time, and it is unfortunate, and I know the team would do the best they can. What tools, if you wish you could have, to address either the amount of workload that the team has or how long cases take, and I know the team's doing best work there. What is it, I just want more budget so I can hire more people, or are there other things that if we could be either advocating for or providing, what would you like to have if you had your druthers to address those issues?
I'm not actually prepared to answer that question right now, and I'll say why. I really want to see how the Streamline program plays out during an election year. I want to see how much we're able to do during that period of time with the staff that we currently have, and then evaluate on the back end, like, yes, we could do more if we had X, Y, and Z. Or, maybe we're at the right place. I don't know, and I don't have an eye toward that yet. So I really want to defer to answer that question until after I have some more information.
I think that'll be really helpful because, we hear about, do you have like open positions, for example, that you can't recruit for, or is every position for which we are budgeted, you have somebody in it?
We have 2 vacancies that we're filling currently. So that's where we are as far as personnel goes. Otherwise, we're full.
Got it. Helpful to know. As I recall, we received a budget cut this year, and there's a tremendous workload that we have, and these are extremely consequential things you do. And so any tools that we can provide you with, again, thank you for noting one of them for legislative purposes. As soon as they pop in your mind, I know I would love to hear them so we can try to help. And of course, after Streamline's been in place a little bit longer, that'll be helpful. So thank you.
Great, thank you. Any other questions for Chief Burton or Assistant Chief Burton on this section? Hearing and seeing none, please continue.
Our last section is our projections for 2022. So as you all know, we have a primary election in June and a general election in November. We do also have a couple of special elections that will be happening in 2022. And we will be coordinating our pre-election focus in the next couple of months So for all of the elections, we will be set to go with our pre-election efforts. Also, the new diversion program is beginning to take shape. We will be working with the diversion program staff to develop our internal procedures for how, and the enforcement division will refer matters to the diversion program. We will also be evaluating the Streamline Program, as I alluded to earlier, so that in 2022 we can determine how they're working and provide a further update at the end of the year. Also, with the passage of SB 686, we will be developing a proactive LLC investigation program, and as that develops, I will provide more details. We also plan to develop solutions for increasing the quality of filing officer referrals. As I mentioned before about the bad referrals, we currently do not have any set standards for the quality of the information that we receive in filing officer referrals. And we have seen an increase since 2019 in receiving referrals with inaccurate information. Some examples, we have old contact information for the filer, the incorrect agency is identified. Sometimes the filer has left office, but the contact information is still the agency that the filer left. Sometimes there's poor intra-agency communication. So not every referral that we receive is directly from the agency where the filer was in office. For instance, our SEI unit, they receive all of the filings for city council members, planning commissioners, boards of supervisors, but those local agencies have to send their the filings to the SEI unit first. And sometimes those local agencies don't notify the SEI unit that somebody has left office or changed to a different agency. There are all kinds of situations where there's not enough communication between the local and the referring agency. Sometimes our filing officers, too, don't follow all of the instructions that we include in our electronic system for filing the referrals, and so information is missing there, like they just leave fields blank, essentially. So our intake team works very hard to reach out to respondents, but inaccurate information is a burden on their time, and it increases their workloads. So heading into an election year, we'd like to have as many efficiencies as we can get. So we'll be brainstorming some ideas for solutions, and if new regulations would be the best option, we will bring those, we will work with our legal division and bring those to you. So that's everything we have for our presentation. If you have questions about 2022, I'd be happy to answer them.
Great, Chief Burton. Appreciate it. Commissioners have questions for Chief Burton? Commissioner Baker?
Could I just get as short as you'd like to make it, a reminder of what the diversion program is and for whom it is appropriate and why it's so new?
Yes. So the basic idea will be that people or committees, candidates, persons who qualify for a streamlined penalty and it's their first time offense will qualify to, they'll be able to participate in the diversion program, which will be a training program essentially, instead of paying the streamlined penalty. So we haven't worked out all of the details yet of you know, how it'll work out between enforcement and diversion, but that's the basic gist, that basically it's like going to traffic school for the Political Reform Act.
I do understand that analogy really well. So, great. Thank you. Appreciate that.
Okay. Any other questions for Chief Burton on her presentation? Going once, going twice. All right. Any public comment on item 5? This is the Enforcement Division update for 2021. Hearing and seeing none, I want to again thank you, Chief Burton. Thank you, Assistant Chief Burton. You guys did a fantastic job today. The information easy to understand, comprehensive, but also the staff in general. Just again, thank you so much for your hard work and enforcement. You guys really do an excellent job, and we are fortunate to have all of you. So thanks, guys.
Thank you.
Thank you.
All right, moving along. Item 6, executive staff reports. Chief Burton, actually, you can't go away yet because now you need to do your division report. Sorry. Anything you wish to highlight for us?
My report is as submitted.
All right, any questions on Chief Burton's regular division report? Hearing and seeing none. Thank you, Chief Burton. Now go to the legal division report. Mr. Bainbridge, you've been quiet today. Anything you wish to point out in connection with your division report?
Give an update since the report came out on the pending litigation. We have just the one case here, the Wallstrom v. FPPC case. We had a tentative order by the court that granted our demur without leave to amend. So what that means is the court was inclined to dismiss the case as to the cause of action against the Fair Political Practices Commission. At the hearing, the court decided to continue the matter until March to give the petitioner the opportunity to provide some additional pleading as to the second cause of action, which does not concern the FPPC. So the case is still pending, and hopefully we'll get final resolution on it in March. With that, I submit the report.
All right. I just want to, because this is something that we continue to see a lot, I would just note in your report you did receive another exemption request for SEIs.
Oh, yes. Yeah, we had another one from a consultant for the Public Employees Retirement System. I believe the interest that is not being disclosed had to do with a spouse's business. If my memory serves, I believe the spouse was some sort of medical or psychiatric business where they wouldn't want to disclose the names of their patients due to federal privacy laws.
Thank you for explaining that. And then I also just want to note from your report for the benefit of the commissioners and the public is the webinars and scheduled webinars that your staff is doing are a good example how we are proactively reaching out and trying to help people with compliance. I note many of these relate to SEIs, and we have an SEI filing deadline that'll be coming up pretty soon here. So this is just, I think, a good example for everybody that these are some of the things that we do to try and help drive up compliance with things like that. So I'm glad to see you doing that and look forward to that continuing.
Yeah, and if people are interested, they can go on our website and go under the, let's see, which tab is that? The Learn tab, and you can go and sign up. We have all of our scheduled webinars listed, and the ones that are open to the public you can sign up for.
All right, great. Thanks, Mr. Bainbridge. Commissioner Baker?
And you can follow us on Twitter because they are regularly tweeted out, and you can share that and retweet it and give it to all your friends.
There you go. There you go. Thank you. Any other questions for Mr. Bainbridge? All right, moving right along. Chief Hahn, good morning still, not quite afternoon.
Good morning.
Technology Division report.
Good morning, Chair and Commissioner. As my reports are submitted.
All right, thank you. One thing I would just note is your report reflects that we do have a new division chief for the new audit and assistant division, Shirley Shaw. And new division chief Shaw is here. You can't see her on the cameras, but she's attending here, and we look forward next month in January to her first division report. So welcome, Division Chief Shaw. Any other questions for Ms. Hahn on her report or comments? Hearing and seeing none. Thank you, Chief Hahn. Any public, Executive Director report. Sorry.
Hello, Gillian West, Executive Director. The only thing I would report on is I know diversion program came up earlier. Early next year, the Commission will be getting a briefing on the diversion program and its progress. And just as a reminder, organizationally, the diversion program is under the legal division because it's considered an educational component of the FPPC. So just want to let you guys know that.
Thank you, Executive Director West. Any questions on Executive Director West's report? Hearing and seeing none. Do we have any public comment on item 6, executive staff reports? Hearing and seeing none, we'll proceed to item 7, commissioner comments and proposed future agenda items. Do any commissioners wish to identify proposed future agenda items? Commissioner Baker?
It's just a request that either in the January or February meeting, if it is a reasonable time frame, and I defer completely to Chief Burton on this, if that's when we know if the age tracking of cases is going to take like writing a whole new code in our system, or if it's something that will be relatively feasible. Not the actual report itself, but just if you have a sense of what that would take, maybe by February, if we're able to know what that is, that'd be terrific. And the only other message is I hope everyone has a wonderful, wonderful holiday, safe, healthy, and happy, and all your families and everything. Lots of cookies.
Thank you, Commissioner Baker, and absolutely, especially on that last part. Any other commissioners have future agenda items they wish? Hearing and seeing none. Well, I'll echo Commissioner Baker's comments about happy holidays to everyone. Hope you have a safe and enjoyable season. And with that, do we have a motion to adjourn?
I move to adjourn.
Second.
Ms. Blanker?
Commissioner Baker?
Aye.
Commissioner Cardenas?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Manich?
Aye.
The motion passes.
Great. Thanks, everyone. We'll see you in January next year. Bye.
Happy holidays.
Happy
Happy holidays.